Subsection A, 995, is the same thing where we have eliminated implied consent for a boat, and I would again point out that we've eliminated the 3-hour rule in this section as well.
Okay. Can I get a motion to add the 3-hour rule back in? All right, I'll second it. All in favor say aye. Aye. Opposed? All right. An amendment adopted.
And section B goes into the blood draw for boating, so that keeps implied consent for the condition of the blood draw, and again, that has the 3-hour rule in it as well. Section C gets rid of the language talking about, shortens the language to such person unreasonably refuses, and gets rid of the implied consent language from that statute to submit to having a blood or breath or both samples taken for testing as required by subsection A. The arresting officer shall advise their obligation, and again, shall advise again is an obligation under current law. Violations, subsection A, violation of subsection B is a civil offense. Violation of subsection A is a period of no boating for 12 to 24 months. It's 24 months for a second and 12 months. So this was actually never a criminal. And correct me if I'm wrong, there was never a criminal refusal for a boat.
Not that I'm aware of.
I didn't think so,
And
but
the voting in the commercial motor vehicles never got changed when the other sections got changed.
of course.
So we left some of that alone. We
Okay.
went in here and just cleaned up some of the other language to conform it.
Page, or again, 29.1738.3, this is presumptions again. This is adding the same language performed by the Department of Forensic Science pursuant to the search warrant. Again, this does not have the language that relates it back to how that blood test is taken, as we just added to the presumption case for DUI.
It also needs to say whole blood too. I don't think that got into this section.
It does not say whole blood as well.
Where are we now?
We are on page 40, line 1052. We need to make the, if the committee wants me to make the conforming amendments to conform this to the same language that is in the 18.2.269 presumption. Section 10, line 1060, implied consent. Commercial drivers, again, this makes the same changes. This actually has a 2-hour rule, which has been struck out. And so if the committee wants to reinstate the 2-hour rule for commercial vehicles, we would need to do that in this section.
Did the other commercial motor vehicles bill that's going through correct that to 3 hours?
Yeah.
So there's
Yeah.
All it did was conform the penalty.
Yeah, we only change the penalties.
so,
Right now, it's still 2 hours.
so I don't know how you guys want to do it.
That's up to the committee members.
That already passed.
I'm talking
It's
about
not a full committee though.
2-hour,
It's not a full committee.
that bill would not conform, because the 2-hour rule is not in that bill.
That's not in the
Penalties,
CDL
different
bill.
code section.
That's something else.
Different code section.
Oh,
That's
right.
just penalties, it's not.
Okay,
rates. So
great.
that bill that we've got in committee wouldn't do that at this point. So we want to conform this to the DUI. Has the motion been made and
Yeah.
done to
Tommy made a
conform?
motion, you seconded it, and it was unanimous consent.
In addition to all the conforming amounts that have to be made, DUI, commercial DUI, the substantive policy question you have to make is whether or not currently under commercial DUI, it's a 2-hour after arrest, whether the test has to be performed as opposed to 3 for DUI. That's the rationale.
Because it's a lower threshold.
I think it never got changed. It used to be 2 hours for DUI, and when they changed DUI from 2 to 3, they ignored.
You get a bill on that.
Yeah, they ignored the changes that needed to be made to the commercial motor vehicle.
I know, I'm sorry, I just can't catch you, I just can't fix everything.
Let's change that. I move that.
Second.
fixing the CDL. So that's the CDL 2 hours.
We conform, we need to conform voting with the DUI and the commercial law to conform to the 3-hour rule. Language. Can we do that?
Did we just do that? That was, I thought was your motion.
Just make sure.
Clearly.
Wait to catch it.
Back to the bill, 1075, page 41. Any person, whether licensed, this is the implied consent for blood for a commercial vehicle. That actually has 3 hours written in it already. 1095, refusal of tests. This conforms the penalties for refusal to the DUI statute.
And this is CDL refusal.
This is CDL. This is all. Now I'm talking about commercial refusals.
Right, gotcha.
Commercial vehicle refusals. This conforms it. First offense, 12 months. Second offense, breath. Class 1 misdemeanor, 3-year loss of license. First offense, blood, 12 months, loss of license. Second offense, blood, 3-year loss of license. Deletes the implied consent language on 1124. And again, this is the same thing we did where we need to do a correct statement of law that we did on the DUI. 1125 through 1137. Same thing. Same language continues that we had in the DUI statute about the obligations, the use of it at trial. Adds the language that conforms to implied consent with the law enforcement person has to do to the for this, since this doesn't relate back to those other statutes. The language has to be added to the statute to do how the law enforcement officer has to execute the form, and that a summons may be issued if it's at a hospital or medical facility to conform with 19273. 1168 is an impoundment of the vehicle for 24 hours. Deletes the language about the warrants and trial being conformed, because that is now in 462341.26:4, 1183. That language about venue of the trial and how it's tried as a criminal offense is in that section now. 462341.26.9. This is your assurance statute. This is the change that was made earlier about changing the person doing the test to any person qualified to conduct a test. 462341.27. Performed on the suspect's whole blood, Department of Forensic Science, and we need to add the language in accordance with the statutes.
All in favor, signify by saying aye.
462391.2 just adds commercial refusal to that statute. That is the administrative license suspension statute. Continues through that. 462, again, these remaining statutes are adding the commercial refusal and DUI statute actually to the license suspension statutes, because they apparently got left behind when the changes were made. Going back to the front, skipped quite a bit.
We're starting over?
Starting back at the front now. We're now on page 1. 2.2511, criminal cases. This is a change that's made about the authority of the Attorney General to appear in civil cases involving refusal. Do we need to add the voting refusal to that statute?
Yeah, I'm sure.
We don't include that.
We just have a rolling motion to amend if we find. Okay, that's what
We're
you're doing right
doing
now.
so. 8.01, 44.5 is a civil statute, and that adds the whole blood test by a search warrant to be admissible in a civil case pursuant to a search warrant when the chemical test is performed on whole blood by the Department of Forensic Science, scientifically reliable. That is for your civil your damages in a DUI or a civil PI case.
We need to pause there real quick. I thought there was an amendment there that I don't see.
That's the only place that they used the word scientifically reliable, and I think they got left in from something else, so if you want it to be phrased exactly as the others, you can phrase it exactly as the others.
But also line 90, I'm sorry, I'll let everyone catch up. Line 95, I thought we were striking new or should have known. It's in the other one?
No, this is, we haven't talked about this stuff yet.
Oh, I'm looking at the one you gave me. This is the one that you put out saying this is the substitute.
No, that, you gave me that. With new language, you strike out language 801 dash.
Oh, sorry, I thought that was already being done. Never
Yeah.
mind. Okay.
No, it'll be in, here, if the committee so votes.
It's like Prego.
Do you wanna do that now, since we're on it?
There are proposed amendments to 801-44.5 that aren't in the substitute. In the second paragraph, I would be striking clause 2, at the time the defendant began drinking alcohol, through the end of that clause, and then making a similar change in the third paragraph, striking clause B.
Okay, so someone needs to explain exactly what's going on, because this is a pretty big change in law. I have to agree with it, I don't think. But isn't this where in a personal injury case, you get punies
Yep.
if a person was driving drunk?
Yes.
And this statute has been very, very difficult to use for plaintiffs because it's so impossible to show, knew or should have known, that his ability to operate a motor vehicle was impaired.
Correct.
Okay, so it's a pretty significant change that would normally happen across the way in civil, so.
And it only came up because we were tearing the entire thing asunder and rebuilding it back from scratch. I agree with the change as well. I think that if someone is, I think that if I'm gonna have a drunk driver on the stand and he goes, well, I didn't know that drinking a 12-pack of beer in an hour would cause me to not be able to operate a motor vehicle, then punitive damages would be difficult to get. And I think that we make the presumptions for a lot of these DUIs, and I think that by the punitive damages we need to do the same. But I agree with the delegates.
I just wanted to make sure we weren't doing the things that sometimes people do. They go blah 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 blah, and no one really knows what's going on, and then pretty soon you change.
Well,
the law.
that's the reason I'm making kind of a big deal of it, because this is a little bit outside our bailiwick.
Devil's advocate.
Tell you what.
So as in rape cases and things like that, when your drink has been spiked, you don't really know that you've been consumed. Is that ever considered, or was that always rolled into what we are about to strike?
You mean that intoxication is a defense?
That you didn't know that your drink had been spiked, that you didn't know what was.
Oh, that's someplace else. This is, I was driving.
I didn't mean as far as rape, I was just.
No, I understand, you're using rape as an example, yeah, I understand, but you're saying that I had 2 glasses of wine, I didn't think I shouldn't have not been that drunk, somebody must have put a shot of vodka in both my glasses of wine. You can still say that, but you can't, what this was saying was, I didn't realize that because of my metabolism, I don't drink that much, I didn't realize I was gonna be that drunk after I drank that much alcohol.
You answer your question. You always need to have involuntary intoxication.
This is civil, so this is for punitive damages. That's what this section. I think Delegate Albo might be correct. This might be a bridge too far in this particular statute, and this might be something that we might want to kick across the hall. But I figured since we were already here, I established a beachhead, so.
They're done.
Love to send them some work.
I'll send them some work. They can look at it. We'll have them review this.
Okay. Because we have to look everything over again anyway, so might as
They
well.
need to feel our pain.
Fox cold pizza.
All right. So we have a solid hour and a half more of work when we get done with this. So where do we stand?
We covered everything, including all the amendments, correct?
Everything I've seen there.
But we need to have a clean version come back out again.
There's a few sections we haven't gone through, but they mostly just conform language in the juvenile statutes to the changes we've made. There's no substantive changes left that we didn't go through.
Mr. Chairman, since you've been doing other things, I would suggest that we put the 5 for the day, and we look at it next time to make sure that all the amendments were done the way we wanted them to be.
That's fine.
So,
Yeah. All right, so what we'll do is we've only got 2 more sessions after this. And you don't do it Wednesday, because Wednesday is our final cleanup, so we'll do it Monday. So put it on the docket for Monday, do it at the end, just each member of the committee. Okay. All right, so I'll entertain a motion to go by till Monday. All in favor, signify by saying aye. Aye. Opposed. Okay. So by my count, we've got about 8 bills left. I'd love to say they're not big ones, but that would be a lie. What I would suggest would be, Albo's got a couple. Gilbert's got one. Gilbert, you have a witness, do you not? Okay, let's do Gilbert's first. 1851, and then I'm gonna ask everybody to rally because we got my bills at the end of there. It's a big one. So, all right. 1851. And if anybody has any of the bills where they witness, they. All the way to the end, Jeff. All the way to the end. I know. The reverse chairman's prerogative.
I understand.
Stick around.
Okay.
Yes, in my little room.
Brings back memories.
You ready? Dave, Albo, pick one of yours. Okay. My first bill is House Bill 1411, and there's a substitute.
I'll move the substitute. First motion, second to adopt substitute. All in favor, say aye.
Aye.
Opposed? Substitute's for us on 1411.
Okay, there's a line amendment. On line 14, I'd like to strike 21 and insert 10.
Second.
All right. I believe it's all right. Once we move fairly straightforward, all in favor say aye. Aye. Opposed? All right.
Okay, so my bill attempted to do 2 things. It deals with courts making lawyers do cases for free. And I've had 2 situations. On the civil side, we've had a number of situations in my law firm where our client either runs out of money or a client decides he doesn't want to pay. You go to court, the judge says, no, you're in because my docket's more important than you. And now you're trying a massive litigation case for free. You can't, so people say, why don't you sue the client? Well, you really can't sue a client because their obvious response is going to be malpractice. So now you're not only trying 2 cases for free, 1 case for free, now you're trying 2 cases for free. I had to punt on that for this time because not all times are the clients the bad guys. Sometimes the attorneys are the bad guys. Think of a divorce case where someone racks a huge bill and then they threaten to drop out of the case unless you pay another enormous fee that's outrageous. So the Supreme Court, I talked to the Chief Justice, just name dropping, and he and I agreed that he would look at this, and I'm not quite sure I can use the word study, right? I can't create a study. So Judicial Council shall, I strike study, insert review.
Second.
Aye. Okay. And this is in their normal process. the Supreme Court would look at these things anyway, so we're not requiring them to do anything they wouldn't normally do. So they're gonna look at the civil side, and I think that's the way to go on that. The one I wouldn't negotiate on is this problem. Have a person come to me with an embezzlement charge, felony embezzlement charge. I charge her, say, $8,000. She gives me $4,000. Half up front is my rule. I know I'm not seeing the rest of it, but you know, I figured I was going to kill the case anyways at preliminary hearing and get a misdemeanor out of it. Of course, when I get there, the story that my client tells me is vastly different than what the police officer's victims say, right? Shocking. So I can't get the case killed at preliminary hearing. I show up to, after grand jury to term day, and I say, Your Honor, my client needs to interview for court-appointed lawyer. Since this thing, she's gone out of business, she has no job. No, you're in. What do you mean I'm in? My fee agreement says that for preliminary hearing, if you want to hire me for circuit, no, you're in. I literally had to try an embezzlement case for free. And I'm so angry that the court was complicit, in my opinion, in a second embezzlement, the embezzlement of Dave Alamo. So what this basically says is that you cannot be obligated to continue defending somebody past preliminary hearing. I originally just wanted to have that, and the court, of course, said the problem is we don't know that you've withdrawn, so we need some kind of notice. And so what we've agreed to do is say what it says here. Privately retained counsel in a criminal case may withdraw from representation of a client without leave of court after the certification of charge by the district court by providing written notice of the withdrawal to the client, commonwealth attorney, and to the court within 10 days of certification charge. And that works for me. I'm going to know after preliminary hearing, you just tell your client, are you going to hire me or not? And if they say, well, I don't have the money yet, then you just file the notice. And we reduced it from 21 days to 10 because the Commonwealth's worried about some speedy trial issues.
Thank you.
All right. So this is a very specific thing. It would be when a case goes from district to circuit, and it's on the certification, that would mean you have to notice the withdrawal.
Right. And you basically have a right to withdraw. I would argue you're not even a lawyer, but I'm trying to compromise so I can get something that works for both sides.
All right. If the certification, delegate client.
Well, I was just gonna ask, I mean, are we seeing this in a lot of cases where the judges are not allowing you to
Depends what
withdraw?
jurisdiction you're in, but Fairfax County has 1.2 million people, and there are a lot of cases there, and it's happening in every case.
When I'm retained, I give them an engagement letter that specifically outlines that if their material facts are different, you say judges are not taking those as.
That's what I said.
Mr. Chairman.
Underline what delegate client said. So your agreement to take it in district court is being translated up to circuit, and you're stuck with the whole case. That's terrible.
Mr. Chairman,
Doesn't mind to limit the level of representation.
as another circuit court judge from my jurisdiction said, attorneys are the last indentured servants left in this country.
I don't feel sorry for lawyers as lawyers. I'm just saying that you should be able to determine the quantum of representation. Right, right.
Well, there's another public benefit to this, and that is that in Fairfax right now, I would have to charge that woman $30,000 up front, and then get the money back if I can kill the case. You know, give the money back, and she's never going to have $30,000 to hire a lawyer. So,
Mr. Chair. I do that too all the time. I tell a client, look, I think based on what you just told me, there's a chance I can get this resolved in the lower court. And because I require all of it up front, because I'm not gonna get paid otherwise, I try to break it up for their benefit, and then if it doesn't work out, I said, we'll have to renegotiate a second deal. But it is to their benefit to have it work that way.
I'll add, sometimes they don't like the job you did in lower court, and that's a good time to switch. And if this is all locked in, that's another opportunity. They don't have to. You're really limiting what your clients can do. Okay. Anybody have any questions for the patron? Staff or council have any issues?
I think we already adopted the 10
Yeah,
days.
I thought we did.
Yeah.
Okay. Anybody in the public need to be or like to be heard on this measure? What's your pleasure on the bill? Motion to make report. All in favor signify by saying aye.
Aye.
Opposed? My next bill is 1525.
Okay, this might take, it's not complicated, but it takes a little explanation. So, if a person gets a federal conviction or an out-of-state conviction, the DMV, once they're notified of it, is obligated to suspend the person's license in the same manner as it would have had the person got a DUI in Virginia, as long as the two statutes are substantially similar. There are statutes where the Court of Appeals or Supreme Court have declared are not substantially similar. North Carolina being one. I think there's case law in New Jersey. In fact, I know there is because I had a big fight with the Attorney General on this, and here's what happened. This case says that the statutes are not substantially similar. DMV, you cannot suspend my guy's license. DMV says, yes, we can, because part of that statute could be substantially similar. Well, how do you know? So DMV, they've always been very good to me, by the way. Very helpful. Calls me, they said, let's call the AG. The AG calls up, and here's what the AG does. Calls up the prosecutor from New Jersey. What are the facts of the case? The prosecutor says the guy was driving on the road, got pulled over, blew a .09. Like, how am I supposed to try that? You know? I mean, you have to judge this on the face of the statute itself. So then what we did was we went down to Richmond. Fortunately, my client had lots of money. Cost us $20,000 to litigate it. One of the sub-issues that the judge in the Richmond Circuit Court ruled was, and Richmond is where you do these things, right, is that you had to judge it on the face. That's only a circuit court opinion. So the purpose of this bill is to say that when you're determining substantially similar, you look at the statute itself and determine whether it's substantially similar. I would have thought this is current law too, except I've been burned 3 times.
All right, everybody understand the explanation? Any questions for the patron? Council have any questions?
Delegate Albo, the language says if any court of the Commonwealth, do you intend it to be the appellate courts of the Commonwealth? So I think that can be read that if General District Judge.
Now I'm remembering that someone came to my office and said that was a problem, and I agreed to say the Supreme Court or the Court of Appeals. Yes, we should change that.
Okay.
Because there's no way for somebody to know General District Court, right?
Or you'd have many different rulings.
Okay. You have language, or you want to?
What are we talking about?
Mr. Chairman, on line 18, after city or town ordinance, you would strike out any court of the Commonwealth and insert if the Supreme Court of Virginia or Court of Appeals of Virginia has held.
All right, not to be stupid, but if the Court of Appeals held it one way and the Supreme Court reversed, the language you just said would not.
21 takes care of that. Takes care of
Got it. Okay. Yeah, you're right. Yeah, you're right. Okay.
I move that.
Is there a second?
Second.
All in favor, signify by saying aye.
Aye.
Opposed? Okay. All right. Any member of the public like to be heard on this bill? All right. What's our pleasure?
Report.
Motion made, second report. All in favor, signify by saying aye. Aye. Opposed? Okay. All right. Delegate Gilbert, you're up.
I couldn't go home, so I'm getting divorced, but I got 2 bills at Subcommittee.
So,
You want us to be careful. What is it?
If I change the rules for if you're seeing me in my divorce, would you please say that you actually saw me here at the meeting?
And that you were invaluable.
No, that's client. Todd, you ready, or what are you doing?
so this is 1851, and you may recall that the policy consideration was to prevent somebody who gets put under the domestic assault and battery first offender program who later violates the terms of the program prevents them from essentially appealing their conviction a year into their probation and starting all over and having to subpoena the witnesses and have a trial and the whole thing, and it just doesn't make good policy sense in my opinion. So we worked through I think the gist of the intent of the bill, but then we had an issue about how long you would have to appeal the,
Withdraw your consent.
withdraw your consent to the initial finding of the adjudication, the finding that facts were sufficient for guilt. So I thought you should have 10 days, just like you have 10 days to appeal. I think the way it worked out, if we accept this amendment that Mr. Cotter has prepared, you would have 10 days to change your mind about that, and then once the judge enters a finding of guilt, because he'd already found you guilty, he would then enter a final finding, and then you would have 10 days to appeal that. So the amendment that will accomplish what I just said, which is that you'd have 10 days to change your mind and then another 10 days to appeal the adjudication or the finding of guilt, is as follows. Page 1, line 29, let me do, all right, so it would say, right now it would say after probation, and don't make a motion yet. It would say a person may withdraw his consent to the deferral and waiver of his right to appeal within 10 days of the entry of the order deferring proceedings, period. Okay, now, so the issue, there's another issue that's gonna disrupt the flow of that sentence. I talked to to Maria at the Indigent Defense Commission, and she made a good point that there are all kinds of things that you could appeal from a lower court, including a judge's finding that you had in fact violated probation, or including the punishment for violating the terms, or whatever it may be. So my intention is not to stop somebody from the normal course of things that they could appeal from a lower court finding, including any of those types of things. It is to stop you from being able to have your trial all over again a year and a half into. David looking funny at the, Maria, can you come up here? All right. Okay, so I'm trying to stop them from being able to start over. I'm not trying to stop them from being able to appeal something they could otherwise appeal, like the judge's finding that they violated or whatever. So on the existing bill, she had a suggested amendment. I'm going to revise it. So let's start with this amendment. After right to appeal on line 28, you would insert the district court's finding that the evidence is sufficient to find the person guilty. And then I think period. And then after that, you would add the other sentence that I said, which is a person may withdraw his consent to the deferral and waiver, etc. So what I propose there, Mr. Cotter, is that after appeal, it's the finding of the district court that the evidence is sufficient to find the person guilty. And I'm drawing that from line 25. So I move that amendment, at least in concept, so that people can appeal other rulings of the court other than whether they are guilty or not. Does that satisfy your concerns?
Yes.
I'll second your motion.
Does everybody understand what I said?
Could you read it again?
Okay.
I'm sorry.
So, Cotter, do you have a better way of putting that, or? All right, so, and you would do it again later. All right, so right now it would say the person consents to such deferral and to a waiver of his right to appeal. The finding of the district court that the evidence is sufficient to find the person guilty. So that's all you'd be giving up. You wouldn't be giving up your ability to appeal other findings of the court, such as, I hereby find you in violation because you missed your classes, or because you said hi to her at the movies and you weren't supposed to have any contact with her, or whatever it may be. So those are issues that they could currently appeal. And I'm not trying to stop them from appealing those types of things. What I'm trying to stop is the victim being hauled into court as a witness a year and a half after she thought this was behind her,
All right, so this is Mr., I guess I'm the chair, I'll ask myself. I recognize myself speak. This is the second bill we've had that is trying to bring evidence that was presented in district court up to circuit court. We had the other one that was also trying to find some way to do that. No, I'm just saying this is the same issue though. Can we do that? The case in circuit court is de novo. We're not appealing an issue. I'm wondering, can we?
You can appeal issues. You don't, not every appeal is a de novo trial.
I think you can waive a right. So while you still might have a de novo right to appeal, while the appeal may still be de novo, you may have waived pursuant to that agreement or accepting that deferral, the right to challenge the district court's finding. And that's why I think that language is better, because then you would be prohibited.
So it goes up, and just make sure I understand that. Well, something. I'm unhappy. She lied. Not the original trial. She said I saw her at the football game and I was told not to have contact with her. Okay. It goes up, and what happens up there? So if you're then violated in the lower court, and you get 30 days in jail, or 10 days or whatever, the conviction.
So I think under current law, you can appeal that.
The whole thing.
Finding, not the whole thing, that part of it, you can say, Judge, the lower court judge said that I said hi to her at the football game, and I didn't, and I want you to decide whether I said hi to her at the football game.
Or
And
they
maybe-
said it didn't complete the class.
Or whatever.
And I proved
Yeah, but
it.
in practice that doesn't happen because of the issues he's raising. Why would you do that when you could, I mean, it's de novo, you can start from dead scratch. You may as well get the whole thing again. Okay.
Under current law, if the issue, let's say you pled guilty and you took first offender, and then you had an argument with it, or they brought you back into court for saying hi at the movies, you say I wasn't even at the movies,
Right.
and you appeal it, the whole case from the beginning goes up.
Right.
Now you can say to the Commonwealth, look, the facts were sufficient last time, I'm not going to cite this, but I'm only want to argue in court about my violation. But there's nothing that's stopping you from that point.
So let's say you were found, just not under this program, but that you were found guilty of domestic assault and battery, and there was a 60-day suspended jail sentence.
I'm with you.
That's, okay, so I'm still trying to keep.
Sure, that's going to come out under a different case because it's going to be either a revocation of probation under a different code section and a show cause or contempt or something like that.
That's all I'm trying to preserve as a right, that they can still pursue those rights and remedies, but I can't start all over.
Mr. Chairman.
I'm the circuit court. I'm just trying to figure out how this comes up. The circuit. So you then, like we said, you didn't go to class. The defendant then appeals. It goes up the whole files. You're over to circuit court. You have waived. Say it again.
You waive
I know what what you're trying to do. I'm just trying to get to see if we can succeed.
waive your right to appeal the district court's finding that the evidence was sufficient to find you guilty. You're waiving that. You're not waiving anything else.
Okay, we do think that would bind the circuit court moment. I mean, I understand not being able to do anything. I just don't want to be in a position where this exception swallows the rule, and by the time we get up there, now it's a de novo appeal, and we haven't accomplished our goal.
Mr. Chairman, another issue is, let's say you go to circuit court and you, by this statute, have stipulated, basically that's what this is the statute saying you're stipulating for the sufficiency of the evidence of the underlying charge. And the court says, here's the evidence that says, you're right, you didn't violate. Now, where are you? Now you're in a new court. Do they put you on probation for another 2 years? Or does it send it back to JDR?
That's an existing problem, if that's a problem. That's an existing problem.
No, you're up there. It's
Yeah,
done.
if you-
That's what I'm saying, but that's what I'm getting at. I think the case is in circuit court and it cannot go back. You have appealed. What you have done is you have stipulated certain pieces of evidence forevermore. When you stipulated in lower court, you stipulated in upper court. Todd, Delegate Gilbert, are you thinking that if this were contested, we're all visualizing this as part of an agreement? Let's say I tried the case in lower court.
Yeah, I think 98% of the time it's going to be by agreement.
I agree. I'm just trying to play this out.
Yeah.
You try the case in lower court. The court finds sufficient evidence, and now everybody kind of looks at each other. And the only way we could possibly work at that point would be to say the guy looks at the defendant and says, "Do you want to participate in the first offender program?"
Chair, if I may, you have to consent to this. So
Yeah, you have to
you
consent.
can only do the deferral if you've consented to that.
Okay.
If you get found guilty, if you go to trial and you're found guilty and you don't like that outcome, then you appeal it. This would
Consensus
only
such
come up if you
deferral.
said, yes,
Okay.
I consent to this.
Okay.
Mr. Chairman, I think the better analogy is, this is a plea agreement where you're waiving your right to appeal.
No, but it can be post-trial. I'm getting at it. In other words, the judge hears it and says, I find it, and then has to take the next step. But that's okay, she's right. I mean, it's there. Okay, if you're comfortable with that, just I'm worried it needs
Mr.
to-
Chairman. So,
Delegate Adams.
the point I'm interested in, I don't have any doubt that the waiver is effective. My question is to what staff raises, with it being, when you can appeal a violation or revocation and it's another case, in this situation, it's typically not another case, it's not assigned another case number because you're being, the violation brings you back on the original charge. And so, so if that happens, what is the mechanism by which you could appeal the allegation that causes the revocation? There's no additional case number typically assigned. Try to listen to him.
I think what would in practice happen is whether there's been a plea of guilty or whether there's been a not guilty plea and a finding of guilt, defendant consents to the deferred, case gets continued out 2 years. Sometime in that 2-year period, there's an allegation that the person wasn't successful. Bring him back in, find him a violation, sentence him, now he's been adjudicated guilty and gives him 6 months, 12 months. Right now, he can note an appeal.
We know that, we get it.
Right, so that's still permissible, except under this theory, he would not be able to then say, we get a complete do-over. The facts sufficient for guilt have already been established, and you don't get to.
Yeah, Becca's got something to offer.
Just on one point, again, Holly Smith, Commonwealth Attorney for Gloucester County, but for BACA today. With respect to maybe Delegate Adams' question about the additional charge number, I can't speak to obviously every jurisdiction, but in a lot of jurisdictions it actually is brought on a show cause with a separate charge number to it. So to address that particular issue, I would speak to that.
That's your bill.
No, I'm happy to, I'd be happy to make that clearer, or to make it clearer that, the whole case doesn't go to circuit court just because they decided an issue. I mean, there are different ways to do it.
I can't think of anybody.
I've had
walking
2
comes
issues,
down.
and I wanna have 2 more because of trying to fix everybody's concerns, so, no, that's a different amendment. I would like to ask the Commonwealth attorneys if they're,
Just generally speaking,
Yes, please.
yes, sir, Delegate, Mr. Chairman, and Delegate Gilbert in particular, I would say that the Commonwealth Attorney's Office supports this notion. This is a much-needed law. The worst case scenario that you have articulated for the committee is exactly what we see routinely. 2 years later, we're tracking down a victim who...
I don't want to cut you off. We all support the notion, I think.
Yes, sir.
So,
Okay.
and we all know what the problem is. I say to both of you, we all have seen this case, we know exactly what's going on. The question is, does this get us there? Does it open new doors? Is there a problem? This is going to be tried all the way up as soon as it happens. And
do y'all have any problem with, sort of trying to fix her issue and, it seems like I'm creating another problem by trying to say that you can't appeal the finding of sufficiency, but you can appeal some other thing that if you were just a guilty defendant and a judge found you in violation, that trying to preserve those rights is...
Respectfully supporting the notion, it does sound like we are creating another issue. Again, we haven't really staffed this with back, and I'm not sure exactly of the language. I didn't see an amendment, just hearing the amendments.
Okay.
It does seem a little concerning that you could have one piece going one direction and another going someplace else. My take at this late hour of what you were trying to accomplish may be mucked up a bit by what's going on right now.
Here's what I'd like to do. And first of all, as you pointed out, Ms. Hall is here. So even though you've said how much you like this concept, I would like her to say it also, because I think she's been sitting here to say, I just like, it makes me feel good when we're doing something together.
Yes, absolutely.
So, thank you, ma'am.
Yes, good evening, Christine Hall with the Action Alliance, and I just wanted to express our support for the concept of what's trying to happen here, and I think trying to figure out a way that you don't have you waive your right to appeal the underlying offense, but I think preserving the defendant's right to appeal any further allegations that occur seems like an important balance to strike, and so I just wanted to offer support for conceptually what's trying to be accomplished here. So thank you.
Thank you for sticking around for that, I appreciate it.
No doubt.
Okay, so I don't wanna rain anybody's parade. but-
Do it.
Do it. Rain. Let it rain.
Hear me through.
Take it.
I like the concept. We had
This big argument in my office in Arlington when Ms. Stamos, who's here today, they started making people, or not making anybody do anything, but requiring that in the case,
Using their vast leverage
well,
to, yes.
requiring as part of a plea agreement that you waive appeal. I totally understand why, because they've got all the witnesses there, and if they give you a deal and you plead guilty and then 10 days later you appeal, then they gotta go redo the case, okay? Now here's the intellectual argument we had in my office. I said, I don't care because the thing's invalid anyways, because the Constitution says you get a de novo appeal to circuit court. Therefore, whatever document my guy signed in general district court no longer exists. It goes poof, because the lower court thing doesn't exist. My law partner, Dave Oblon, says that's not true, because you can waive your constitutional rights. You can waive your right to a jury.
We're making him a judge, not you.
Yeah, right, exactly. Okay, so I think he's right, and I think Theo's doing a good thing by doing this, but hear me out on this. That argument still exists out there, right? So if we take it and we start monkeying with this concept just in 18.257.3, aren't we now saying that every other time there's a waiver of appeal, it's not valid because the statute was only, the grant of the right to appeal was only given in 18.257.3. What do you think?
asking me? I mean, I don't think that's right. I mean, I think, just as my colleague from the Indigent Defense Commission just said, you can waive all sorts of rights. And so, as you know, in Arlington, when we agreed to a deferred disposition in JDR court, and we work out an agreement, we asked defense counsel to sign a waiver of the appeal so that we're not stuck 2 years down the line trying to get our victim back. And that has worked pretty well. I mean, we had some issues in circuit court if the judge didn't sign the waiver, and we've been litigating whether they can now waive, as Delegate Gilbert is saying, now they've been found guilty, they can appeal the court imposing the 60 days.
That's not what he's asking. What he's saying would be under the omnibus exclusive idea that, right? What he's saying would be if we put it here,
Yes.
we have by inference not put it every place else. And therefore, even if it works here, have we then by inference, and this is good legal doctrine and statutory interpretation, said you can't do it anywhere else? Now, we're very careful about this because this is a good defense. We're assumed to know everything that we do is on purpose and that we didn't put it anyplace else on purpose. And
I don't think that's a problem because it's a very specific statute. It's a deferred finding statute, unlike other statutes where it's a more general one. I don't think that theory would apply. I don't think putting it specifically, anyone, you guys agree? Because I don't think spelling it out specifically in a statute where you already have a deferred finding, unlike a general law statute like, grand larceny or something, you're not going to be bound by that theory.
Yeah, but see, I don't know what the answer is, and we wouldn't know if we passed this until it went to the Court of Appeals.
on a grand larceny that you wanted to hold someone to,
But
they
wouldn't
wanted
it
to
be better to take the same concept, which is super for this statute, and put it into the part of the code which talks about de novo appeal and make it apply to everything? That if you...
I had that bill too.
Yeah.
Too late. I had that bill draft.
I already did mine.
Did I?
Well, you could just,
excuse.
But, you know, I think that thing that you guys do is smart. I mean, because why should my guy get fights his behalf after you already gave him a deal? And why should you have to drag the victim back to court and redo the whole thing when the victim was probably not happy that you gave him the
So it's working our way.
Yeah, I just want you to know that I'm not trying to stop what you're doing. I think it's great. I'm hoping we don't do damage to this concept by passing this.
I would hope not.
Yeah.
But I don't see it I don't see this as a problem, but
Delegate, we
Mr.
got
Chairman,
4 more bills.
so I would like to keep working on Ms. Jankowski's issue. And maybe she can work with the Commonwealth attorneys to figure out how to make that work. And I would like to just offer the amendment proposed by Mr. Cotter that says, after the word probation on line 29, any person may withdraw his consent to the deferral and waiver of his right to appeal within 10 days of the entry of the order deferring proceedings, period.
Okay. All right, then you make the motion and someone needs a second.
I just did make that motion.
All in favor signify by saying aye.
Aye.
Opposed. Sorry, Delegate Gilbert.
I move to report.
Okay. So, any other member of the public like to be heard on this measure? Okay. Motion is made to report. Is there a second? All right. All in favor signify by saying aye. Aye. Opposed. Okay. All right. All right. Home stretch, but we've got a couple. I know. All right, everybody, we rally for 30 minutes and we're done. Can we do that? I need you guys, these are my bills, and unfortunately that means that, well, I need somebody to bet them besides me. All right. So, those of you in the Crime Commission, which is at this point, I guess just Gilbert has heard this, let's take up 1855. So, a year ago, you sent us off to the Crime Commission with a notion that restitution is broken. And we all thought that it might be $1 million or $4 million. And the Crime Commission study did in fact find outstanding restitution. And it was $406 million. If that is not a shock to conscience figure, it ought to be. And even if you accept that some of it will never be collected and the person is in prison for life or dead or destitute, it is a preposterous figure. I mean, it's extraordinary, right? You could, all right. So we have two bills. One is the first one, 1855. Mr. Cotter, you've got the sub.
3 line items.
You didn't do a sub.
Not 3
That's fine. All right. If you would go ahead and report the line amendments, please, and I'll go through it. And then this is the smaller of the 2 bills. This is mostly technical and shouldn't be particularly controversial. Go ahead.
Mr. Chairman, the first amendment is on page 2, line 66. After defendant, insert comma, the date by which all restitution is to be paid, comma.
On a form.
Yep.
Drive by the Supreme Court.
Okay. We'll do it in a block. Dave, go ahead.
The second amendment is also on page 2.